Hi, I'm attorney Alan Castro here at Horton Mendez Injury Attorneys. Being injured at work can cause a lot of stress and frustration, and you may not know exactly what you're entitled to. Employers and carriers don't necessarily make it easy and make the process as clear as they can for you, so that's why we're here to help. One of the first things to understand is your employment status, whether you're a true independent contractor or an employee that may be entitled to the benefits. One of the key indicators as well is whether or not your employer has 3 or more employees. Here in the state of North Carolina, any entity that has 3 or more employees is required to carry workers' compensation insurance. If you are a true independent contractor, meaning that you have control over how you do the job, you may use your own tools and have wide discretion about how you execute and perform your job, you may not be entitled to workers' compensation benefits. For those who are entitled to workers' compensation benefits here in North Carolina, the law gives injured workers strong protections. Today I'm going to walk you through those rights and provide some examples to best protect yourself in moving forward when an injury occurs. One of the first and very important things to do in this process is to report the injury. Immediately is most beneficial for you. Directly after an injury occurs, make sure you are okay first, obviously, but then make the call to your supervisor or boss to make sure that they are also aware of what's going on. From there, they are supposed to direct your treatment. The first step in the process that is extremely important is to report the injury to your supervisors and your employer. This makes sure that everyone is notified directly after something occurs that this injury has happened and how it happened. Once your injury is reported to your employer, that triggers an obligation for them to report that same injury to the insurance carrier. This will also have them file what's called a Form 19 with the Industrial Commission, also notifying the Commission that this injury has occurred. This step is crucial for the credibility of the claim. There is often times that carriers and employers will say, well, we just didn't know about it. So they tend to call into question the credibility of the incident if it takes weeks, days, or even sometimes hours to report the injury. Imagine you slip and fall at work, and weeks go by until you tell your employer. One of their first responses is going to be, well, how do we know this happened at work? Why haven't you told us? And that calls into the credibility of the injury happening the way that you say it did. Immediate reporting acts as a hedge against this so that everybody has perfect clarity about exactly what happened immediately after it happened. In the perfect scenario, after you report this injury immediately after it happens, your employer should direct your treatment towards their providers. This is typically a visit to the urgent care, to where you can make sure, again, that you're solidifying your reporting to your providers exactly what happened and how it happened, so they can start the process of giving an appropriate diagnosis and set a trajectory for your medical care as soon as possible. In a claim where the insurance carrier is accepting responsibility, they have the unilateral right to direct the treatment, so long as it's medically necessary to help you heal. This means that they get to tell you which doctors to go to, when to be there, and what course to follow. Again, that's in an accepted claim. Now, in a denied claim, you are responsible for your own treatment, which can make things difficult because then you have to bill either your own insurance or come directly out of pocket for medical care. If the claim is accepted and you're directed towards their providers, there will be an assessment on whether or not you should carry work restrictions. This can mean a change in what your regular duty might be. There may be a lifting restriction, a bending, a twisting, a stooping, something like that, where you're just restricted of doing a normal activity that you would be doing in your normal job. If an authorized treatment provider imposes these restrictions on you, it is then up to your employer to accommodate those restrictions. Prior to reaching maximum medical improvement, accommodating these restrictions can come in many different forms. But there's a caveat that no matter which form it comes, the job description needs to be sent to the authorized treatment provider to sign off on that job to make sure that it's truly suitable for you to perform. So I mentioned the term MMI, maximum medical improvement, and there is a distinction pre and post maximum medical improvement within the law of what is suitable employment. If you get down to the end of your treatment through an authorized treatment provider, and they make an assessment that you're as good as they're going to get you. You are maximally medically improved. However, they continue to impose permanent restrictions on you that's outside of your normal job routine that you did pre-injury. It's still a situation where you have to be suitably employed, which means a job that you can perform now under your permanent restrictions within the context of your educational background, your work history, and pays you the same that you were making at the time of your injury, with an additional caveat that it has to be within 50 miles of your home. So, just on a macro level view, the perfect case scenario is that you immediately report your injury, they start sending you to providers, you go through your course of treatment, and if you have to be out of work, they start paying you weekly, and they take you through the course until you reach MMI, and then at that point, they're able to provide you with suitable employment. To discuss the time out of work a little bit further, there are some things that you need to know. The first is that you won't be compensated 100% of what you were making while you are out and restricted from working by the doctor. You'll be compensated at 66 2/3% of your average weekly wage. The notion being is that about a third of everyone's paycheck goes towards things like taxes and benefits and other things that you don't actually receive the benefit of. So 66 2/3% is what you would expect to receive on a weekly basis if your claim is accepted. There are some differences though if you are totally temporarily disabled or whether you're partially disabled. What that means is that if you return to work, but you're either making less or in a different position that gives you less hours, and there's a difference in what you were making and what you are making currently, that would be a temporary partial disability. It's the same notion of the difference is covered at 66 2/3%, but there is a distinction whether you're completely out of work or whether you're back to work but in a diminished capacity. Upon reaching MMI, the doctor may also make an assessment on the body part itself, whether there should be a permanent partial disability rating assigned. Every body part here in North Carolina is on what's called a schedule. Every body part is worth a certain amount of weeks, and a percentage will be assessed upon that number of weeks. For example, if you injure your back at work, your spine in its totality is worth 300 total weeks. And if you go through a course of treatment through an authorized treatment provider, they get you to MMI, and they also make an assessment that you are 10% disabled for the injury that occurred to you. That number would be assessed on the 300 weeks, meaning that you would be entitled to 30 weeks of your compensation rate, which is that 66 2/3% of your average weekly wage. The ideal scenario is also when you report your injury to your employer and they file what's called the Form 19, they also provide you with another form that's the Form 18, and that's your opportunity to make the claim. Oftentimes, no matter your reporting or how legitimate your injury may be, insurance carriers will make the decision to deny your claim. And in that scenario, it is crucially important to retain counsel as soon as you possibly can. In that scenario of a denial, what needs to happen is a filing for a request for a hearing, which is called a Form 33. That is your appeal, essentially, of the insurance carrier's denial. You're notifying the commission to say, we disagree with their denial and we want to be heard on the issue. Making that filing will trigger the industrial commission to acknowledge that filing. And in that acknowledgement, the parties will be ordered to mediate the claim within 120 days of that acknowledgement. More often than not, a claim will resolve at a mediation once the parties exchange information through the discovery process. But if the parties are unable to reach an agreement, the claim will proceed to a hearing. Within the hearing process, there is lay testimony, which means typically the testimony of the claimant, and the testimony of employer representatives and other folks who are non-medical providers. Then the doctors will have their depositions to give their opinion on causation or symptoms or work restrictions or otherwise, and any other experts that may be retained in the case. Then, from there, the parties will submit their contentions on the opinions and award that they're seeking from the Industrial Commission. Typically, the defense will say that the claimant is not entitled to benefits, whereas the claimant will say the opposite. Now, in this scenario, the commission will never give a dollar figure amount for an award. The only thing that the industrial commission will do will give a thumbs up or a thumbs down on responsibility. So they will either say, yes, employer, you are responsible for the time that this person has been out of work, or yes, you are responsible for paying for this medical treatment, or conversely, no, you are not responsible for this injured work. One of the elephants in the room in these situations is typically retaliation. Claimants are very worried that the employer will retaliate against them for making a claim, and that's flatly illegal. They cannot retaliate against you for making the claim. Now, of course, there are other reasons that anyone can be fired. If you're terminated for a reason that anyone else would have been terminated, the employer may be able to meet their burden in that and say that the termination was legitimate and not retaliation. So my biggest piece of advice is just to be on your absolute best behavior, be on your P's and Q's, make sure you're doing everything that you are supposed to do so that you don't lend them an argument to terminate you, whether they want to justify it on paper for being late or absent, or whether it's truly a retaliatory act. You want to be able to protect yourself as much as possible. It's also very important to understand your right to legal representation. You always have the right to a workers' compensation attorney. The carrier certainly has their own attorneys, and you should level the playing field and get your own. Ultimately, the attorney acts as the guardrails, making sure that all deadlines are met, that benefits are maximized, and you are getting everything that you are entitled to. If you're injured on the job, please visit our website or give us a call, because we're here to help and we're here to guide you through this process. Thanks for watching, and be sure to like this video and subscribe, and we'll see you next time.